But they gave it.
Just saying everything.
May I please, your lordships? Item 12, 13 and 14. This are listed for hearing. I pray that these matters may be taken up after the vacation. I know that lordship has fixed so many items for tomorrow. And today we have some.
How are these maintainable? How can we issue a repetition in at least two of the items?
Lordships.
That's all. No objection. But earlier the better.
Yes, my lord.
Lordship.
Mr. C.T. Zamir, learned senior counsel, appearing for the respondent. You are for the respondent in all the three cases.
Yes, lordships.
In all the above noted writ appeals, submits that the matter be adjourned today and taken up after the ensuing winter vacations. Prayer is not objected to by the learned counsel for the appellants.
No.
Full stop. Accordingly, registry to list this matter immediately after the ensuing or after the reopening.
After the winter
courts,
vacation.
after the ensuing winter vacations, on a date to be fixed by it.
Lordship, lordships.
Please, Lordship. I beg to mention item number 1. Let it be listed after a week, Lordship. I have
Wait.
not received after a week.
Why? Give me a reason for that.
I have not received instruction, Lordship,
You are appearing for?
for the Union of India. On the train list.
But the road this time I found it's slightly better.
Your lordship, this is a different.
Different,
road.
But it's not the
No,
other one.
This is
Okay.
a different. road.
Okay. On the prayer of Mr.
CGC.
Uh,
Gauhati.
learned CGC. The matter stands adjourned today. Full stop. The prayer for adjournment is not objected to by the learned counsel for the petitioner. Learned amicus curiae
No, my lord.
for the petitioner. Full stop. Registry to list this matter again on
On 10th, my lord.
10, 12, 10, 11, 10,
10, 12.
10, 12, 2025.
Much, Lordship.
Much.
Please, your lordships. Lordships, if I may be allowed to move an unlisted motion for a habeas corpus petition, your lordship.
Habeas corpus.
Yes, your lordship.
But bring it before 1 if you can. Habeas corpus.
I'm obliged, your lordship.
May it please lordship, lordship, I beg to mention, hearing item 15 and 16. Lordship, the appellant, they have filed the affidavit recently, so I need to obtain instruction in that affidavit. So I pray that this matter may be listed after the winter vacation.
You are for the state.
Yes, for the state.
This is that
That's
Hindi,
it.
Hindi.
No, no, no.
No, it's not Hindi.
This is
It's
it.
SSA,
Oh, SSA,
RMSA,
okay.
yes.
We would have asked him what is the error in the judgment.
Yes, there is no.
Justice
error.
Borua's judgment.
Yes, yes.
Mhm.
We would have asked him that if he had not taken an adjournment today. They were brought over in 2022. That is
Yes.
your case.
Yes, yes, yes.
And in an
No,
appeal,
seniority.
in an appeal, we will only consider what is there before the writ court. We can't have, at least if there is some further development, you can always.
Yes, but lordship, they have annexed some documents where the department, they have given the confirmation of service.
Confirmation of
date of,
service will
yeah.
not undo,
Mm.
will not grant them seniority, madam.
True.
Anyway, after the vacations, then,
Lordship.
let them enjoy the Christmas.
No, we are in service. We're not deprived of.
No, no, no.
Yes, of-
Vince, I don't want you to have a depression before the. Find that the judgment has taken care of all the aspects, subject to what you find you may say.
I would have hoped to satisfy your lordship.
Oh.
Otherwise, my lord.
We'll try. Adjourn it. 15 and 16 on the prayer of Miss so-and-so learned government advocate, who submits that she would be required to receive instructions with regard to the contentions and documents brought on record by the appellants in an affidavit filed in the matter recently. Prayer is not objected to by the learned counsel for the appellants. Yes. So additional AG, huh? Additional AG, madam. Additional AG. I'm sorry because I'm not very acquainted. Registry to list this matter immediately after the ensuing summer vacations on a date to be fixed by.
Much obliged.
Please, your lordships. Your lordship, I beg to mention item number 19, 20, 21, and 22 on hearing matter. If it may be listed after a week, as the senior counsel had to leave out of station for an emergency matter.
What happened to the matter? Similar issues, you said that on the last occasion that this is pending consideration before another division bench. That judgment has come.
That has been
What is the judgment?
directing the state government to consider the case if they come under the policy of the government.
So we
Yes.
can't go beyond that. We will only direct for that, madam.
Lordship, if it could be adjourned.
You don't permit us to do some work. I've come from Gauhati, so I'll have to have show that I have done some work here.
Yes, lordship. But as the senior is out of station and I'm not in this matter.
So they have same only. We can't, it's going in your favor only, ma'am. It's going in your favor.
Lordship, no consideration is also needed because here in this case, there are no more in service. They have already retired. They filed the.
But ma'am, I have found here, just last week, you have contradictory judgments coming in.
Yes.
On one hand, the state has conceded to the fact that, okay, we'll consider. Whereas on the other hand, you have said, no. So it has gone up to the Supreme Court. In one case, Supreme Court has said, no consideration is required.
Lordship, we have not considered the case.
No,
The
one
matter-
case, it went up to the Supreme
Yes,
Court.
the-
The Supreme Court said
But the
nothing.
question of law was left open by
Left
the
open.
Supreme Court.
And the another division bench, I think, is taking up similar issues.
Yes.
What is that writ appeal number? We'll tag it along with that. Can you give it to her? I think it's listed today only somewhere.
Lordship, all the matters are listed today.
Okay,
Yes.
there's 3 matters.
19 to 22 and.
There is one more.
19 to 22 and item number,
One more is there.
yes, item number.
Madam, we'll pass the order when we reach that. We'll pass the order when we reach that.
Okay.
If required, we'll tag it with those pending matters. Don't worry.
Much obliged.
Much.
Previous Lordship, Your Lordship, I beg to mention hearing item number 10. Wait. Your Lordship. Lordship, I pray the matter be listed next week.
Okay, let it be there. We'll pass it when orders pass, when the matter is reached. Okay.
From the supplementary cost list for motion, item number 23.
Yeah, please, Your Lordship. Lordship, this PIL is directed against illegal land settlement orders issued by the Deputy Commissioner, the District Administration of Parent without government approval, Lordship. Lordship, the petitioner belongs to Parent Village, and he had also served as Secretary of the Village Council of Parent. Lordship, the villagers over the years, initially in the year 1948 and thereafter in the year 1995, had donated more than 2,000 acres of land, free of cost, for establishment of Beren Township, which has been now upgraded to district headquarters. Now, Lordship, the state government, the deed of agreement subsequently is Annexure A and B. I am not referring to that. My Lord, at page 51, by an order dated 13 November 1978, my Lord, the Land Revenue Department has passed an order that district administration cannot issue allot land patas, land settlement orders without approval from the state government. Now, my lord, the petitioners were hearing rumors that still over the years that this district administration has been allotting land patas to private individuals without government approval. And that was confirmed at page 52 when the petitioners came to know across the RTI reply of 11 January 2021. My lord, Lordship may kindly see the replies. New land permit was issued to the public at Parent Down from 1992 till 2020 with government approval. 49 numbers of land permits were issued to the public at Parent Down without the approval of the government from 1992 to 2013. One land permit has been issued to public at Parent Down without approval of the government during the month of August 2015. Copies of the land permit enclosed. Lordship, in spite of condition 4 copies of the land permit enclosed, it has yet to be issued. And Lordship, the whole particulars from page 53 is given. The name, book, let number, serial number, date of issue, location. Interestingly, Lordship, at serial number 26 and 27, it is blank. Then from serial number 34, Lordship Nikandi said 54, from 34 to it jumped to 39, 5 serial numbers are missing in the RDI reply. From 34, serial number 34, at page 54, it goes straight to 39. Lordship, the petitioner managed to obtain 2 land patas, which is at page 55, type copy at 56 and 57A, which is, Lordship, not included in the list of 49 already given in the RDI reply. Interestingly, on verification, it was confirmed that this 2 land pata was issued against standing government quarters, Lordship. Okay. Then, my lord, Lordship may kindly come at page 58. Accordingly, an RDI was filed again on 14/11/25 to obtain all the documents, but we are yet to obtain it. So, on the basis of the report given in the RDI, Lordship, we are filing this present PIL. Then, my lord, at page 59, a land settlement order was issued on 24/11/2015 without government approval. Accordingly, on 9 October 2025 at page 60, it was cancelled. And however, the remaining still remains. It has not been interfered with. Lordship, besides the violation of the government order, standing government order, Lordship, the petitioner as one of the landowner, it is the interest of the villagers that the purpose for which the land has been donated by the free of cost should be utilized judiciously, not in the manner in which it has been rampantly distributed, violating all the rules and regulations, Lordship. Accordingly, a representation was submitted, Lordship, and my lord, which is at page 61, but no action has been taken, Lordship.
This was submitted sometime in 24.
It was submitted, yes, it is, Lordship, it is submitted in 25 only, 2025.
2025.
It is not 2024, Lordship.
It's written 24,
Yeah, Lordship,
1610.
It is a typical, by mistake, it is entered, but it is 16/10/2025, Lordship.
But if that's just a recent thing, it's only last month that you have
My lord,
submitted that.
but then the issue
And
is.
this issue is going on for a long time, and
Yes.
at least we find that at page 60, one patta was cancelled. Now, if the deputy commissioner is not taking steps to recuse it, why have you not approached the government why are you before this?
My lord,
court?
the point I'm making is because we have been approaching personally to various
No,
authorities.
that is different thing, but with black and white on paper, we only find page 61.
Lordship.
PIL should be the last resort. PIL should be the last resort when
My
you
lord-
have exhausted all your.
My lord, the
remedies.
point is the manner in which they have been,
No, we got it.
that has been
But this is
regularly over the years.
Mr. Council, this is being done from 1992. Suddenly you have woken up, rightly so, although late, better late than never. But now why don't you approach the government first and thereafter see that if there is no response from the government, you can always come back. Because there may be some justification, we don't know. But only that RTI reply, no land, no permission from the government was taken. We don't know what is the policy. Because normally lands are at the disposal of the district administration.
Lordship.
But I find that there is a bar for them to allot lands without the approval of the government. But now this is no longer your land. This land is a government land now. So it's up to the government to utilize it in its wisdom.
Malab,
Can you,
the point is this, Lordship is, Lordship, because there is a government order, standing government order, which I have shown. So on the
then,
basis of that
then,
government,
then,
standing
then
government order,
if we have to now pass orders,
at page 51 is the standing government order, Lordship.
This
order is not.
being heard by
We'll issue a notice.
Lordship.
But Mr. Learned Senior Counsel, assisted by Mr. Tinsulo, Learned Counsel for the PIL petitioner. Also heard Mr. So-and-so Learned Additional Advocate General, State of Nagaland for the respondents number, for the state respondents. Full stop. The petitioner, by way of instituting the present PIL, has assailed the action on the part of the district administration of the district of Peren, Nagaland, in allotting lands, government lands, without taking the approval of the government in accordance with the order dated 13/11/1978 issued by the Special Secretary to the Government of Nagaland Land Revenue Department, which mandates that the district, that for allotment of government land, prior permission of the government of Nagaland is required to be procured. Full stop. The petitioner has further projected that he and the other villages of Peren village had in the year 1970
My lord,
had donated lands for setting up of government facilities in the area. And it is these lands, and these lands are also involved in the settlements affected by the district administration, which is assailed in the present proceedings. Also, in view of the above, issue notice, returnable 4 weeks. Mr. So-and-so, can you accept notice? So-and-so accepts notice on behalf of respondent number 1 to 4. Full stop. No formal notice is required to be issued. However, requisite extra copies of the petition shall be furnished to the Learned Counsel for the state respondents by the Learned Counsel for the petitioner. Petitioner to take steps for service of notice upon the respondents number 5 to 49 by way of speed post.
Lordship, besides speed post, kindly allow me to publish through newspaper.
No, that is substituted. First, we will have to do. If you fail, we'll come back. By way of by through speed post, steps within 3 working days from today. Registry to list this matter again after 4 weeks on a date to be fixed.
Lordship, I'm bringing for an interim order to direct the Deputy Commissioner Perin to produce all the relevant records, especially those records.
Let them come. Let them come.
That is the interim prayer, Lordship.
That
Then let the interim be considered on the next day, Lordship.
That we can always ask them. That is not in a form of an interim order. The records they are bound to produce.
Then
Not to answer you.
Lordship may kindly give direction to produce the record on the next day.
Let them come up with their stand, Mr. Counsel. You are there. Let be here with us for a month or so.
Lordship.
We'll see.
Lordship, much obliged.
For admission, item number 2.
In this case, it is coming to an second.
May I plead, Lordship? Lordship,
Yes.
I'm appearing on behalf of the petitioner, Lordship.
Hmm. Yes, what do you have to say?
Lordship,
Yes, madam.
Yes, Your Lordship, this matter was endorsed by my colleague. She's in this post, Your Lordship, because of
We got
medical
it.
reasons.
Have you extended the period of detention?
No,
Because
it's
coming to an
still-
end on
Yes,
2.
yes. So the records is with me. I tried to draft the affidavit and I have sent today. So now the records are with me. So if this honorable deems that it should be taken today, then basing on the records, we can dispose it off. Otherwise, maybe tomorrow so that I can file the affidavit and pick it up.
Have it on Monday,
But
better.
both
Monday
items
is a
2 and
holiday.
3, Your Lord.
Monday is a holiday.
Yes.
It's because it's coming to an end on 2/12.
Two, yes.
So,
One is on 2 and one is on 6. Both 2 and
both are
3, it's been
6.
endorsed to me. Your Lord.
But what about the extension? Have you considered the extension or you're not
Yes.
considering?
Your Lordship, I have not received any information to that because this file was endorsed to me and I have actually drafted the affidavit and sent. No information has been
You are
according to me
Amy.
so far.
You're.
No, I am not Amy. I am Livika, Your Lordship.
Oh, you're Livika.
Yes, Your Lordship.
Miss L.
Livika.
Livika, a learned state counsel, submits that that the affidavit on behalf of the state respondents represented by her is ready and she would file the same by Friday.
By tomorrow or? Okay.
By Friday.
By-
By Friday. Full stop. With a copy to the learned counsel representing the petitioner. Full stop. Registry to list this matter again on 2/12/2025. The 2/12/2025. Full stop. We are fixing it on 2/12. On that day, we will consider all the 3 matters.
Lordship.
That we'll ask her orally. You get your instructions with your extension because if it's not extended, that'll be the end of the
Yeah,
matter.
that will be the end.
In all
Lordship.
3 cases, pass the same order but different orders.
Your Lordship, even on the item 3 also.
Oh, 3, 4, both.
Yeah.
2, 3, 4, huh?
Or it's not given to me. Only 2 and 3. It's
No,
endorsed.
notice by whom? Madam is there. In item number 4, you're filing an affidavit, madam?
I've already filed this morning. Your Lordship.
You're fine.
It's on file.
Miss
Lordship.
formally,
Lordship.
you have got a copy?
Regarding item number 4, this morning only I was informed by my learned counsel that she has filed her affidavit.
Yes.
So Lordship, I have not gone through the contents of the affidavit.
We'll have it
So-
on second. You come
Lordship.
with your instructions by that day.
Lordship,
Miss so-and-so learned government advocate submits that an affidavit on behalf of the state respondents has been filed today. A copy thereof has also been furnished to the learned counsel for the petitioner. The learned counsel for the petitioner submits that he be granted time till 2/12/2025 to complete his instructions in the matter. Post of prayer accepted. Registry to list this matter again on 2/12/2025.
Lordship.
Tuesday, huh?
Third, we said division bench only on Wednesday.
Oh. We can have a division bench on that day for that, because this matters we cannot. Second, because first I find is a holiday. First is a holiday. 2/12, Mister.
Lordship.
For admission, item number 5.
This is that road. This road.
Affidavit filed,
Yes.
government.
Lordship, on the last 2 occasions, because of bereavement, I was absent. So Lordship, before we come to the affidavit filed by the state government, Lordship may kindly allow, your Lordship may kindly allow us me to review the order passed on 24/9/2025. Because on the
24/9.
24/9, Lordship, on 29/10, because of time constraint, this order was not reviewed.
2910, yes.
Lordship, kindly allow me to read, Lordship.
Hmm.
Lordship, I'm reading from paragraph
2.
5. Oh, man. Lordship, the document supplied to me is one page is missing, page number 4 is missing. The 24/9 order 25. My lord, in my copy. Yes. Lordship, I'm reading from paragraph 4. Paragraph 3. On 16/7/25, the Deputy Commissioner Chumukitima was granted time to file a detailed affidavit on the
Just you're reading order dated
24/9/2025.
24/9. Yes, yes.
I'm reading from paragraph 3. Yes,
Hmm.
But from paragraph 3, Lordship. On 16/7/2025, the Deputy Commissioner Chumukitima was granted time to file a detailed affidavit on the issue of taking necessary steps for dealing with the problems arising at Dimapur Kohima National Highway at NH 126. Lordship, in difference to the order dated 16/7/2025, the Deputy Commissioner Chumukitima had filed an affidavit on 12/8/2025 in order to address the following issue: acquisition of land and compensation for widening of riverbed at Bagla Bahar, shifting removal of PHE pipeline from the site, unfortunate incident resulting human casualties at Bagla Bahar. It is relevant to mention that it has been suggested earlier that acquisition of the land at GNH 126 at Sutuku Range, early known as Bagla Bahar, for expansion, widening a river bank would be necessary. In order to address the above three issues, the Deputy Commissioner has stated that the proposed land for expansion, widening of the river bank was surveyed and assessed, and the estimate of the same has been forwarded to the Deputy Commissioner on 10/2/2025. The parcels of the land proposed for acquisition belong to the Department of Tourism and PHE of the Government of Nagaland, and compensation amount has already been dispersed. In evidence of disbursements of payments received have been enclosed to the affidavit. In also, for a shift removal of the pipelines belonging to PHET for Jati Riverside is concerned, it has been averred that the matter has been resolved and the pipelines are to be shifted simultaneously to the rock cutting. It is stated that NHIDCL has been accorded clearance to proceed with rock cutting. On the third issue, it is stated the ex gratia amount of 4 lakhs has been approved for disbursement to the next kin of the deceased who succumbed to death in the incident occurred in the stretch of NH 29 on 30/5/2025. Mr. Imsung, learned additional AG, has submitted that as regards the shifting removal of the pipelines belonging to PHC, the department has already issued a no objection certificate to the NHIDC. Mr. George, authority engineer, has submitted that the parcels of land acquired for expansion, widening of river bank have already been handed over to the NHIDCL. He has submitted that the notice inviting tender has been published, inviting bids to carry out expansion, widening of the river bank. It is further submitted by him that the tender process has been finalized, and presently the process is at the stage of issuance. The work order to the successful bidder, he has also submitted the works expansion, widening of the river banks are going to be started immediately and in all possibility in the month of October 2025, and the time period to be given to the contractor for completion would be 4 months. He has also submitted that the shifting removal of the pipelines belonging to PHC will also be simultaneously done. It has been canvassed the sinking recurrently occurs at NH 164 of the national NH 29. On the previous day, Mr. Muzoe has submitted that in view of massive landslide resulting in sinking of NH 164 area, there was necessity for issuance of a fresh work order for additional component. This court directed the respondent number 15 to appraise this court regarding the progress made in connection with the remaining works. Taking into account the respondent number 15 has given an undertaking that works would be completed by September 2025. In the affidavit filed on behalf of the respondent number 15 on 23/9/2025, the respondent number 15 has stated that the physical progress achieved so far is 78.32%, meaning thereby the milestone to complete the remaining works has been shifted. Mr. Muzu has submitted the NHIDCL authorities are contemplating to construct a viaduct on the stretch of NH 29, and that connection, the respondent number 15 has already submitted a proposal. Mr. George, authority engineer, has submitted that after receipt of the proposal from the respondent number 15 and another proposal from DPR consultant regarding construction of viaduct FGNH 164, the NHIDCL authorities has examined the proposals and thereafter forwarded to the IIT Gauhati for expert opinion regarding feasibility of the proposals. Once a report from the IIT Gauhati regarding feasibility or otherwise the construction of viaduct at GNH 164 area is received, the NHIDCL will take appropriate decision in the matter. Mr. George has submitted an up-to-date status with regard to the proposal of viaduct would be placed before this court on the next date. The respondent number 19 has been awarded two packages, which was termed package number 1 and package number 3. The scope of work of package number 1 is slope management and rockfall barrier works in and around GNH 164, the one GNH 127, and the scope of work in package number 3 is slope management. On the previous stage, the respondent number 19 was directed to file an affidavit as regards the status of the progress made in respect of the remaining parts of package number 3. Mr. Chairman, counsel for respondent number 19, throwing attention to the affidavit by the said respondent on 15/7/2025 has submitted that the tentative date of completion of the remaining works in the aforesaid GNH is 30/11/2025. It is stated by respondent number 19 in the affidavit that the accident on 30/5/2025 occurred between GNHs 125,552 and 126,700. It is stated during the May 2025 there was traffic diversion in that area at the instruction of the NHICL authorities for the purpose of carrying out river protection and road widening. In the area where accident happened, rock protection works were not done. The reason behind the accident was fall of a rock from the hill in that area. Council has appraised this court that recently on 49/2025, there was a massive landslide at the areas between GNH 124 to 128. As a result, there was complete hand-in traffic halt in the traffic in the national highway for a substantial period of time. Authority engineer has submitted that as regards other side of the Jati River, which is near the National Highway 29, the NHIDCL authorities have appointed a TPR consultant to come up with a permanent solution in order to avoid recurrence of landslides, rock falling, shrinking, etc. In that stretch between 124 to 128, the consultant has also been asked to provide solution to stop rock falling also in the area. He also submitted that the DPR consultant has submitted a feasible report, and the NHIDCL authorities at the highest level are analyzing the report of the DPR consultant, and the NHIDCL authorities are deliberating to find a possible permanent solution. Mr. Church has submitted that if PIL is listed after a month, he can address this court as regard the progress in this direction. Learned counsel appearing for respondent number 19 has submitted that he has filed an affidavit today. In view of the subsequent incident in the area, he would like to file an additional affidavit to supplement the affidavit filed today. The leave sought by Jamir is accepted. The additional affidavit is to be filed on or before the next day. As there are repeated landslides and sinking causing severe obstruction, hindrance in the flow of traffic and endangering public safety, as well as disruption of essential connectivity in the stretch between GNH 172 to GNH 184.540 of the National Highway, the court on earlier occasion directed the Public Works Department, State Government to work out a possible solution on priority basis. So, my lord. Now, with regard to the hill cutting and other issues, the learned additional AG, it was informed on the other side, the contract has issued and wrote a hill cutting on the other side of the river has started. That is, my lord, the rocky area just after Patkai, as you start from the Mapur, that particular portion. And in certain particular portion, Lordship, the road was totally damaged.
Sinking.
So, see,
now, here we find that there are 2-3 aspects considered in this
Lordship,
order.
Lordship.
Now, the first one we find is that the first issue was acquisition of land and widening of the river.
Yes.
So that is progressing.
Yes, already done.
That is already done.
Yeah.
My lord, I
And,
issue wise order may be passed.
And the shifting of the
Yes,
PH, that is also done.
it's also already started.
Okay. Now, what about the viaduct?
Why didn't also simultaneously they are going on now?
Viaduct.
Viaduct is different.
164.
Because we have already submitted the proposal to the NHIDCL. So they are analyzing all our rules.
That finalization has not occurred.
Let the NHIDC's council, Malad, highlight on the viaduct.
Yes.
My lord.
Okay, just before we go there,
Malad, the
One is
operating
the
engineer is
MI
appearing.
okay, he's appearing online. One is the 164 that Chenich the viaduct.
Yes.
One. Two is the proposal sent to the IIT.
Wow.
IIT Gauhati for approval with regard to the viaduct itself.
Yes.
Okay. What do you say on that? Para 12.
Sir,
With regard to viaduct lordship, the authorities they have already examined. We are waiting for the final confirmation from the authority lordship.
From which authority?
IIT Guwahati lordship.
They have not submitted.
Yes, lord.
Yes, Mr. George, the IIT authorities have not submitted their report.
their final report has not come. They had to do some soil investigations at site, which they carried out. They did soil investigation at multiple locations, and their lab some testing is going on. They said it will take some more time to give the final report.
Now, some more time means they have got the materials in their hand. It's only analysis now that has to be done.
Lab testing, they have to do lab testing of the soil samples.
The analysis, they have got the
Analysis.
materials, now the analysis. How
Analysis,
long will it take?
They didn't give a firm timeline, but roughly they said it will take around 2 months.
2 months from when?
Out of which about 1 month is already over.
Already over.
Yes.
And the slope management package number 1 and 2, that is done by the state.
No,
No, that is awarded by the whom? By the NHIDCL?
lordship.
By the NHI.
Package 1 to 3 is under jurisdiction of the NHIDCL.
NHIDCL, sorry. Yes, what is your progress?
Lordship, I have kindly come to my affidavit, Your Lordship.
You can make an oral submission.
No, Your Lordship. In fact, Your Lordship.
You were supposed to complete the works by, when are you supposed to complete the works?
Expect to be complete
30.
by 39/2025, Your Lordship. Now, Your Lordship, in package 1 and 3, Your Lordship, we have been allotted the work for supportation work, Your Lordship. And in package 1, to install rockfall barriers, Your Lordship, 2 type of work. Now, those slope protection work which we have completed, Your Lordship, due to incessant rain and fall of distinct debris, stones and boulders and trees, Your Lordship, some of the slope protection work which were completed were also damaged. That is why I have filed an additional affidavit bringing on record the present status, Your Lordship.
Now, if you have constructed there,
Yes, Your Lordship.
have you not factored in that these are the calamities that the area faces? And then you take a prevention measure while you are doing the construction. You're not asked to just construct.
No.
You are constructing it
Yes.
because it's a perennial problem there.
Yes. But
So if it is damaged subsequent to your construction, that means your construction was not either proper or not done by taking all factors into being.
Your Lordship, the problem is that the stone, the boulders, whatever, and then the debris that fell, Your Lordship, that is beyond the ROW, 100 feet from above, Your Lordship. So that we are helpless.
So what is the point in giving you a contract to do a part of the work when the main problem still
Yes.
subsists?
So that is why, Your Lordship, we have again sent a proposal to the NHIDCL.
This would be an unending problem.
Correct. I admit,
This will never have a solution.
I admit, Your Lordship.
You have been allotted the work by whom?
But NHIDCL, Your Lordship.
Yes, Mr. George, what is this work you are doing?
The scope of their work, sir, we had a limitation of.
Scope of the work we understand. You are an engineer. But when you are allotting a work, that particular work is for slope management, rockfall barrier, etc. Now, would you only take a part of the hill into consideration, or you will take the whole problem into consideration and then come out with a solution?
The initial order what was given to this parties, that was only covering up to the ROW.
Why did you give him that order? Why did you give him a part order when you could have contemplated that this had a problem which is beyond the area of scope of work?
Lordship,
Why was that not taken into consideration?
Lordship, may I intervene for 2 minutes? My lord, the authority engineer is only the implementing agency.
You know that, and I'm
The
just asking.
NHITSL is to be answerable. Initially, lordship, just to keep lordship, keep giving you a background. Initially, my lord, he put only wire mesh. That was the first contract. And then it was all damaged in one season because it was not feasible at all. Then they came up with this proposal to construct, to put rock barriers, rockfall barriers. My lord, the rockfall barriers are about 20, 30 meters above, the maximum 50 meters. But then above that, lordship, it is falling from 200-300 meters above. And my lord, the depraise that is flowing up from the mountain door, that the rockfall barrier is not able to resist.
No, that's
That
what
is
I'm
the-
asking you. When a
No, my lord.
project is contemplated, it has to take all the factors into
So, my lord,
consideration.
That is what I'm highlighting, lordship. Initially, wire mesh, it was a total failure.
So that money-
Thereafter, you have
That
already
money
removed.
gone down the drain.
It was all removed.
Hmm.
They have removed all the wire mesh, then the rockfall barrier. Then in one season, half of it is damaged, and then fatal injuries because the stones are flying above the wire mesh.
My lord, currently a DPR consultant.
Now you have to.
So permanent solution is required. A permanent solution, not in the beast.
Yes, Mr. George, what would be the solution in this connection?
Regarding the permanent solution, NHIDCL has already appointed a DPR consultant who did a comprehensive study for the whole area. The entire mountains are studied. They have taken the full data. Now they have submitted the feasibility report, which is approved. Currently, it is in the design stage. Once the designs are approved, there will be another tender which will cover the entire slope of the total stretch, package 1, 2, 3. That
Mr.
will.
George, as a for my assistance, I'm not asking this question to put you in trouble. When you had contemplated or conceptualized the work which was carried out by respondent number 19, why was this aspect not taken care of? You had experts with you who could have visualized this problem, because that loss of money, it's public money which has gone down the drains now. Who will now bear that loss? NHIDCL will have to bear it. Why? Why it came around to that?
We have asked the consultant who designed from IIT Mumbai to have a site visit. They have studied everything. Right now, they have submitted their report also.
No, I'm not on that. The work order issued earlier for package 1, 2, and 3. Why was it issued without taking this aspect into consideration? Is there a reason for that?
That was not a permanent measure. That was only for certain stretches.
You were asked to do a permanent solution for that problem. And that is why you allotted package number 1, package number 3.
Only in certain locations.
Please don't have knee-jerk reactions for such works. It will not work out. And now we are monitoring this issue. It will be helpful, because this is also public money which is being expended without any, it's a loss. Now that money is gone. He will not do the work again for that money, because he has done what he has to do. That is gone. Now you'll have to do again for that, him or anybody. Now, how do we assure ourselves that this problem will not be repeated again? How do you assure us? As from the NHIDCL side, how do you assure us that, okay, we permit you to do this, but this will not be repeated the next season?
The DPR will cover everything, sir. The DPR will cover the total requirement.
Are you sure that it will be a permanent solution?
It will be a permanent solution. It will be a permanent solution.
Can you put it on affidavit?
Yes.
NHIDCL will file an affidavit.
Can NHIDCL put that assurance before this court that what happened, why the work was done with not a full examination of the hill as a whole, and now that you have done it, that it will be a permanent solution?
Now DPR study is going on, and that will be a permanent solution. DPR study, once this report is come.
So by when can you give us an affidavit on that it will be a permanent solution now?
Next hearing.
That affidavit should come from the NHIDCL.
So that's what, no. I'm only interacting with him as a representative of NHIDCL, as a technical person. I'm just trying to understand. That's all. NHIDCL will file the affidavit. Mr. George, I'm not asking you to file an affidavit. I'm just taking an input as a technical person from you.
Next date, we will get the affidavit filed.
And also explain how the initial DPR leading to package 1 and 2 was prepared, and what was why the lapse had occasion. Yes.
Then, Lordship, another issue in that particular stretch at 126 kilometer, Lordship, since you were not able to widen on the hillside because it was very rocky, my lord, on the river side, where Lordship must have seen, we have extended by constructing the Gibeon wall. For 2 consecutive years, that is washed away. So, my lord, thereafter, my lord, what is the permanent solution? That is also another aspect of the matter to be examined, because in that particular stretch, they are not able to construct under the hillside. So on the river side, they need to come up with a permanent solution. Of course, hill cutting is one aspect of the matter, but then the route has to be widened to 4 lane.
We'll come to it. Now let's now assure ourselves that the works now that would be done taking all the required scientific and technical inputs into it. This is not taking us in. This money is going down. It's my money. Why should we allow it to be expended? Mr. George, how long will you take to file an affidavit with regard to the river works pertaining to the riverside, the washing? It said that it has been washed away now, and the stabilization of the slope, and it doesn't come. You cannot say we only took 50. We did not consider the hill as a whole. Now you said you have considered the whole area. So how long will you take to file a detailed affidavit covering all these points? Means NHIDC.
Request for 1 month. Request 1 month.
How long will it take?
Lordship, at least 2 months time, Lordship, because the DPR consultant is on the site, Lordship. He's examining.
No, he has taken Mr. George says that the data have been already collected.
Lordship.
Now it is being analyzed.
Lordship, to be on the safer side, Lordship, at least 2 months time too.
I also request for that because we have to detail because.
Fine. Let us have a definite assurance from you this time. And now the work has to proceed, because moment the rainy season starts again, in hilly areas like Nagaland, you can't expect work to be done in the water required.
Understand.
You can't put a big tarpaulin there and then do the work. It's not permissible. So you will have to bear with the weather gods also. So this is today we are on 26th. It will have to go immediately on reopening them.
Lordship, yes. By then 2 months will certainly.
Last part of January, Lordship.
Look, Mr. Takamasa, learned senior counsel and amicus curiae, has taken this court through the order dated 24/9/2025 to highlight the fact that the respondent authorities have not taken all requisite steps for having the road constructed so as to protect it from the varies of the climate, from the varies of the from natural calamities. Also, he submits that the package number 1 and 3 awarded to the respondent number 19 for slope management around chainage 124 to 127 was carried out by the respondent number 19. However, the DPR prepared for the work in question, being so prepared without taking the whole area into consideration, due to the debris falling, DEBRY, falling from heights above the extent to which the management activities were taken up, has resulted in total damage of the works carried out in the matter. He has further submitted that the works relating to river protection and road widening have also not been carried out after a due scientific examination being taken and a DPR prepared after all technical parameters were factored in. This court had the assistance of Mr.
George.
What's your full name, Mr. George?
Shaju George.
Mr. S. George, Authority Engineer, NHIDCL, who has clarified that a consultant was appointed to study the entire hill area between chainage. Just here, if I'm making any mistake, kindly correct me. Chainage 124 to chainage 127, and the technical data which are so required have been collected, and the matter is presently
Consultant is appointed for
under
all the three packages.
analysis for
Consultant is appointed for package 1, 2, 3, the entire stretch of package 1, 2, 3.
2 and 3, package 1, 2, 3. For the entire hill area involved in package number 1, Roman 1, Roman 2, and Roman 3. He submits that the analysis of the data collected is presently underway by the experts, and a DPR in this connection is expected to be prepared within a period of 2 months.
No. DPR actually feasibility report was submitted. Now his designs are going on.
So when will be the DPR ready?
I need to get his final timelines. I am not.
2 months? 2 months?
Yeah, 2 months should be.
2 months. A DPR would be ready within, would be finally prepared within a period of 2 months from today. He also submits that the viaduct contemplated at chainage 164. He submits that in connection with the viaduct to be constructed at chainage number 164, the data required have been already collected and forwarded to the IIT authorities of IIT Gauhati, and the same is being analyzed by the experts therein. He submits that a feasibility report in connection with the same would be submitted shortly, and thereafter the NHIDCL authorities would take a decision thereon. He also submits that an update in this connection would be given to this court on the next date of listing.
Through an affidavit, Lordship.
Through an affidavit filed by the NHIDCL authorities. With regard to the river protection works, the NHIDCL authorities have submitted, the Learned Council for the NHIDCL has submitted that an update therein also would be brought on record on the next date of listing. Also, the issues highlighted herein above shall be addressed by the NHIDCL authorities in the manner indicated above by them today, by way of filing a consolidated affidavit before this court on the next date of listing. The NHIDCL authorities shall also incorporate in the said affidavit any further precautionary steps that may be required to be taken so as to ensure that the road on it being constructed is open to traffic all around the year, and the same is not being damaged as seen with the works already carried out. First of all, the NHIDCL authorities in its affidavit shall also highlight as to why the construction activities carried out with regard to package number 1, 2, and 3 around chainage 124 to chainage 127 came to be damaged, and why, as to why the factors leading to damage of the constructions carried out therein was not foreseen by the experts of NHIDCL when the DPR for the purpose was so prepared.
Lordship, on the same 3 packages. For the first 2 packages, Lordship, I would like to know from the authority engineer whether the defect liability period is over or not, and whether, if not over, whether it is maintained.
The affidavit shall also disclose as to whether the defect liability period for package number
1 and 2.
1 and 2 is in currency or has expired.
Lordship.
Because if he comes with that also, he has done it only with regard to the DPR.
Lordship, then with regard to package number 3, which is ongoing, construction is ongoing, my learned friend is appearing. Lordship, the steel bridge, Valley Bridge. Lordship, since July, August, my little friend was assuring that they will resume construction, but so far, last week I visited.
Now,
the place.
is Bailey Bridge a permanent solution there?
Lordship, it's in supplement to the existing bridge. Because
No, you are contemplating a Bailey Bridge.
It's
for
half
the-
constructed.
it's half constructed.
It's not a Bailey bridge, it's actually a steel bridge only. It's a normal steel
Steel bridge,
bridge.
not a Bailey Bridge.
Normal steel bridge, not a Bailey bridge.
Very
A
still.
Staley Bridge.
Yes.
Bailey
But
Steel
Mr. George, for my understanding, our understanding here, is a Bailey Bridge a permanent solution?
This is not a Bailey bridge, actually. This is a steel bridge.
It's a permanent bridge.
It's a permanent bridge, permanent bridge.
Okay.
Simply for the understanding.
15 now.
Lordship, here, Lordship, sorry, my learned friend, the stipulated time period is already over.
Yes, Lordship.
And he has given an undertaking that he will complete within the time, undertaking was given before this honorable court that the respondent of the tree shall complete the project within the stipulated time. That has expired already, but then the road is, as per the last affidavit, are less than 80% completed.
And that is also by NHIDCL.
Yes.
It is by
package number 3.
NHIDCL.
Work issued to May. Lordship.
NHIDCL authorities shall also, in the said affidavit, incorporate the status with regard to the
Steel bridge.
steel bridge constructed at, what is the
Chainage 155.
chainage?
155.
At chainage number?
165.
155.
155.
165.
Mr. George, 155 or 165?
The steel bridge is at 155. At 165 is another bridge.
155. Oh, stop.
And the progress of the work of at package number 3, Lordship, because
But that is under package number 3. This
Yes,
steel bridge.
because
With,
one of the,
along with the progress of the works involved under package number 3.
yes. Then coming to the last, the affidavit thing being filed by the state with the last, by the state government, Lordship.
Mm.
As directed, Lordship, my lord, I have received a copy this morning. Now a contractor is already appointed. So my respectful submission, Lordship, if the contractor
Affidavit filed.
and annexure A, page 7 of the affidavit filed. by the-
I don't think so. We have received that affidavit. Have we? File is still. Okay. 24 November, okay, yes.
My lord, Lordship may kindly see the work order is at page 7, annexure A.
Hmm.
So, my lord, my respectful submission is that let the contractor be implemented as a respondent in the present case.
Okay.
Thereafter, we will do the needful on the next day.
Okay. The chief engineer, PWD, bracketed National Highway, has filed an affidavit on 24/11/2024 and has therein brought on record a letter of acceptance, bracketed LOA, issued to S. Sem and Co. Lower Agri Colony, Kohima, Nagaland, with regard to the work of one-time improvement of NH-39 bracketed old from kilometer 172.900 to kilometer 185.540 under PWD NH Division -1 Kohima. Also, Mr. Masa, Learned Senior Counsel, amicus curiae, submits that the contractor now appointed for the said work be also impleaded as a party respondent
Number 21.
in the present proceedings. Full stop. Accordingly, registry is directed to implead S apostrophe, S Sem and Co. Same thing, Lower Agri Colony, Kohima, Nagaland, as a respondent number 21 in the present proceedings. The CI, the name of the newly impleaded respondent be incorporated in the case records and a notice in this connection be issued to the said newly impleted respondent number 21
Let it be to Chief Engineer, Lordship.
through the standing council. Who is the standing council? PWD. Through the additional advocate, Mr. Unka naam likh lijiye. Through the additional advocate general, Nagaland, Mr. So additional advocate general, Nagaland. A copy of the present process of the PIL petition, PIL Somoto petition, be furnished to Mr. So by the registry for onward transmission to the newly impleted respondent number 21, through the chief engineer, PWD, bracketed, National Highway, bracket over Nagaland. The CIS records be also updated by the registry before the next date of listing. Registry to list this matter again on January after 26th. Madam CFA. Let us have it on 28th.
Lordship.
28 1/2026.
Much obliged, Lordship.
I think we have covered up everything.
Yes, Lordship.
But Mr. Masa,
Lordship.
please to ensure that in future in this state such activities don't take place, please be highlighting the fact that why the work has been done in such manner. Earlier works.
Lordship.
Because that's a default
Lordship.
planning.
Lordship, in fact, the previous hearings also, this was highlighted, Lordship.
But
Yes.
please do that. Otherwise, this will continue.
Lordship.
Obliged.
Much obliged.
I sincerely apologize, but the item 3, which I'm the council, was being adjourned without my consent and without being called out. And I've discussed with the state council and she's ready to take up the matter based on the evaluation.
We have fixed it on second. They have filed an affidavit. They are filing an affidavit. So we have fixed it on 6th along with the other on second.
My lord,
2nd of
the
December.
detention expires on day 6.
Oh, 6th, we are having it on 2nd.
And state council is ready to take up the matter based on the available reports.
There are other 2 matters also. We'll take it up together on 2nd with the affidavit.
If extension order come, my petition will become infructuous. I have to file.
It will
additional
not
affidavit.
become infructuous. It will be there. There will be no problem because your initial, it's not the extensions which are being considered. It's your initial order of detention that is being considered. Your case is that this can be taken care of by the normal criminal procedure, right? We'll have it on 2nd. We'll have it, consider it on 2nd.
For admission, item number 6.
This is the one.
My please, Lordships. Lordships, my apology, but if this matter can be accommodated next week, I'm not keeping well today, I have some problem today. If it can be accommodated next week.
No, let this is an appeal by the state.
Here.
I'll not trouble you much. We'll not trouble you. You take your seat. We'll ask you 2 questions only. Yes, what is your ground?
Lordship, state is there.
Oh, state, you are the state.
For the appellate, that's why.
Okay, who is for the respondent? You are for
I'm
the
for the respondent.
Oh, you're not keeping well, take your seat. You have argued. Yes,
Lordship, this is state.
it is compassionate appointment.
Lordship,
Educate us on,
hardship, Lordship.
educate us on compassionate appointment.
Lordship.
Hardship mitigation when?
Lordship, immediately, Lordship.
After 18 years, forget the compassionate appointment. Should the judges have compassion?
Lordship, including this appeal, Lordship, this is the 5th round of litigation.
I'm sorry,
Lordship.
but we cannot forget the fact that it is down 18 years now. Where is the compassion? Generate the compassion.
Lordship, I understand that, Lordship.
You generate the compassion, you get the order.
Lordship, when the second writ petition was filed, the state respondents, they have finished a document.
We admit to all those issues.
Lordship.
But today, can a mandamus be issued?
Lordship, direction is already issued on 3 occasions.
That direction, when there was a contempt, that contempt got closed, then you come up for the 3rd time. But after 18 years, be that as it may, It's a default, clear default on part of the state authorities. But in spite of that, whether this court has the power.
Lordship, when the second read petition was filed.
When was it filed?
Lordship, it was in the year 2017, Lordship.
17.
There was also a read petition, Lordship.
Then
Earlier
the
in that-
third writ petition was filed when?
Lordship, I'll just come to the orders, Lordship.
You give me the dates of the writ petition.
Lordship, yes, Lord. The first was WPC number 34 of 2017, Lordship.
WPC, first case.
Yes, Lordship, the first case.
WPC number?
34 of 2017.
Now,
And it was disposed by an order dated.
okay, fine. Your father died in 2008. Now tell me, for 9 years, how did you survive?
Lordship, there
From
was
2008
specific amendments in the read petition as to the condition of the family, Lordship.
I got it, but you survived. Why did you not? Because on the date of the death of your father, this problem had started with you.
And I immediately approached the authorities.
You applied.
By way of an application.
You
Lordship.
applied. There
Yes,
was many confusion. Indigenous, non-indigenous. Now everything is done away with. But for 9 years, you sustained.
In fact, Lordship,
9 years, 2000.
This-
Then this order was passed on. First order was
the
passed.
first order was 6/4/2017, Lordship.
Okay, then what did you do?
Lordship, there was a direction to the respondents to consider, Lordship.
Then what happened?
No, Lordship, there was no time frame.
Forget it. In compassion, they cannot.
Now I was compelled to approach this local court by filing another read petition. It was numbered as WPC number 291 of 2017.
Same year.
Yes, Lordship, in the same year.
This was disposed of with the recording the submission of the government advocate.
Exactly, Lordship.
It was disposed of on?
On 16/8/2018. 16/8/2018.
Okay, then you filed a contempt.
Contempt.
When did you file?
Contempt was numbered up as COP 33 of 2019. COP 33 of 19.
And that was disclosed on?
It was closed on 2nd December 2019. 2nd December 2019.
And when did you file the connected? Then this is the third writ petition you.
And the third read petition was filed, yes, Lordship.
When?
WPC number 141 of 2020. 141 of 2020.
2020. And that was disposed of by the.
Disposed on 12th November 2024.
Now, what do you say about the cap from 2008 to 2025? This order was passed on?
The latest order, Lordship, in the latest read petition. 12/11/2024, Lordship.
So on 12/11/2024,
Lordship.
whether the ingredients requisite to be satisfied for issuance of for consideration by for issuance of a direction to the state to consider the case of the appellant or the respondent for appointment on compassionate grounds was existing.
Lordship.
Generate compassion, I'm here.
Yes, Lord. In fact, Lordship, your Lordship is sitting a single bench only on Tuesday. There was an order to directing the respondents to consider my case.
I just got the certified copy, I just got the typed out copy, I just corrected it. It was only 6 years.
Yes, Lordship, I agree, Lordship.
It was 6 years and there were
2019.
2 applications.
Yes, Lordship.
I'm very careful on this.
Yes, Lordship. In that case,
You mean to say I made a mistake there?
No.
Not signed it yet.
no, Lordship.
I have not signed it yet.
I'm not on the line.
Sorry, this would send a very wrong signal. It pains both of us. It pains,
Lordship.
but we can't send a wrong signal down there. We'll consider everything, but we are dismissing it following Devabroto Tiwari, Supreme Court. Right now? We are allowing the thing, so. 33 onwards.
If your Lordship may kindly consider that aspect. Because in the year 2017, I was.
You were authorized pension?
Lordship.
Pension In the family pension after the death of the government servant,
Yes,
how many members are there in your family?
Lordship, 3 members.
3 members. What is the amount you're drawing now?
Lordship, I have to get instruction.
Fine, no need. No need.
That's what we
We'll presume. 3 members.
In the year
You,
2017.
your mother, and
2 other siblings, Lordship.
2 other siblings.
Youngest
Mother,
sibling.
mother is still alive.
Yes, she is still alive.
And see how this lawyer boy has wasted his life. He's not doing anything else.
No, Lordship.
From
fact-
2008 to 2025, a life is lost. Because he was under the impression that he will be accommodated in a government job.
Yes, Lordship.
That's also painful. This should have been nipped in the bud itself.
In fact, I became overage when the order was
Now
passed.
we will give it a quietus so that the boy now starts looking for some other avenue of livelihood.
Otherwise, the London Single Bank has relaxed the
It
age.
cannot be. It cannot be. It cannot be.
Invoke the relaxation clause in the.
You can always approach the government if you want, I can put it on the order that if there is a direct recruitment. But that again is you can always approach the authorities for relaxation of your age by showing these factors.
Because that relaxation clause was invoked only.
But
in that
again,
particular matter, Lordship.
33, you are only eligible for a grade 4 vacancy.
Lord-
You're matriculated.
Yes, Lordship.
You can't be a grade 3, you can't be considered.
No, Lord. I
Now,
cannot-
grade 4 in this state is totally reserved for indigenous people. Now, how do you
Yes,
come in?
And now,
That
even in the
factor-
writ petition,
How do you come in?
the state has taken a stand that I'm eligible only for technical post since I'm not an indigenous inhabitant.
That's it. Either
That was
way,
the
you're
stand.
not eligible.
My respectful submission before the London Single Bench was, this is a welfare scheme, Lordship. That general exemption should not apply in a welfare scheme.
See, when we are sitting this side, we understand your pain. But at the same time, that post would now be put up for recruitment and it'll go to an suitable eligible person who may be also from the fringes of the society, but an indigenous person, but from the fringes. Right? If you're eligible, you participate. No bar. I'm
I
sorry.
appreciate that I'm eligible only for technical post. I need to have some technical qualification to appear for any. technical post.
That's not the responsibility of the state.
Lordship, I agree. But Lordship, may kindly appreciate just one aspect, Lordship. In the second read petition, the state respondents, they produced 4 vacancies. And also the second information, the instruction provided was, the senior was in the list, Lordship. And that is, on that such kind of instruction, the read petition was closed, giving a direction to appoint against any of the vacant posts. Any of those
But
posts.
that did not occasion.
So the latest read petition was passed to enforce the earlier direction, Lordship. All those aspects.
There is a consistent line of authority of this court on the principle that appointment on compassionate ground is given only for meeting the immediate unexpected hardship which is faced by the family by reason of the death of the bread earner. When an appointment is made on compassionate ground, it should be kept confined only to the purpose it seeks to achieve. That is the idea being to provide. The idea being not to provide for endless compassion. That's why I said, generate that compassion. We are here.
Lordship, if I may be allowed to play the judgment, which if sometime may be given, Lordship, Bank of Canada, Lordship, it was passed in the month of February, Lordship, this year. Paragraph 28, it says that if I was diligently following, Lordship, that has to be appreciated, Lordship.
You're not diligently following.
Lordship, I have
You
immediately
had
submitted my application.
diligently followed from 2017 only, not from 2008.
I have immediately approached the authorities, Lordship. I was under the impression that my application will be considered, Lordship. And approaching this honorable court was my last resort, Lordship.
We are not concerned with your client, but I don't want to destroy your Christmas by requiring to prepare an SLP in the meantime. Prepare the SLP after the vacations, after the winter vacations. Heard the learned counsel for the parties. Heard Mr. So-and-so, learned counsel for the appellant, and also Mr. So-and-so, learned counsel appearing for the respondent. As prayed for by the learned counsel for the parties, Mr. So-and-so, learned counsel for the respondent submits that he would address this court on the issue as to when, on the issue, he would address this court that the court can, even after passing of 18 years since the death of the government servant, pass a direction upon the respondent, upon the state authorities to consider the case of the heir of such government servant for appointment on compassionate grounds. Just put in an indication. Registry to list this matter immediately after the ensuing winter vacations. It's only you we have considered. Like this is Christmas will go.
For unlisted motion, item number 26.
May it please your lordships. Lordships, this is a habeas corpus petition. The petitioner may proceed, your lordship.
When was he put under detention?
On 7/10/2025.
Order has been extended.
No, your lordship.
It will come to an end on
the 12, I think. It was for a period of months. It's January.
3 months.
It's in January.
It will be till January, 7/10.
10.
Sure notice. Yes. But Mr.
Kohima, your lordship.
Kohima, learned counsel for the petition. Also heard Mr.
Jim Young Hong for respondent 3, your lordship.
And who is for 1 and 2? State counsel. Any state counsel?
I'll accept.
Mr. So-and-so accepts notice on behalf of the respondent number 1 and 2, while Mr. So-and-so, accepts notice on behalf of the respondent number 3. What's up? Issue notice. Returnable issue notice. As all the respondents are represented, no formal notice is to be sent. However, requisite copies of the writ petition be furnished to the learned counsel, learned counsels representing the respondents. The respondents to complete the learned counsel for the respondents to complete their instructions and file an affidavit in the matter by before the next returnable date.
Lordship, if I may be allowed to take a chance on the 10th of December this year, Your Lordship, the last day of division bench.
Can you file your affidavit by then?
Your lordship, at least 4 weeks time.
Complete your instructions. When does it?
My lord, at least grant 3 weeks time to file affidavit, my lord.
This order is coming to an end in 7th of January.
Yes.
So he'll have to give him. This is preventive detention. We can't take it normally. The main case is that naturally it will be the same case that this case can be considered in the normal criminal proceedings. And you were placed under arrest, and then it was.
Yes, Your Lordship.
Have they reflected that in the order?
Yes, they have reflected that I'm under custody.
They have reflected that.
Yes, Your Lordship.
Okay. Registry to list this. Complete file affidavit. छोड़ दो, काट दीजिए. File affidavit काट दीजिए. To complete the instructions. Full stop. The learned counsel for the state respondents, respondent number 1 and 2 shall produce the records in original on the next date of listing. Registry to list this matter again on 10/1, 10/12, 9.
So it should be 9.
No, 9.
10, madam.
10. Okay, 10.
God bless you, Lord.
12/2025. You get the records.
Much.
For hearing, item numbers 7 and 8.
Easily matter pending, if it is pending. At least said it's not. But he said it is, but he has not given any reasoning for.
He was not giving any reasoning. When the government says it is not.
No, that's not. Mr. Soikia, you are appearing for? Okay. And who is for the writ petitioner? You are. Now, what is this issue with regard to the 2013 Act?
It applies, man.
How do you say that? Has it been applied? Has the state legislature adopted it? 371 cannot be taken very lightly.
Agreed, my lord.
And the only thing I found in the judgment is that your submission that it's a replacement, but even if it is a replacement,
my lord,
it's a beneficial thing. It's a beneficial thing. We can't allow Mr. NHIDCL, Mr. Soikia to have everything by paying peanuts. He'll have to pay good amount. But still, what about 371?
Firstly, my lord, whether it is the old act or 2013 act, as far as land is concerned, no compensation has been paid.
No, under the old act, 1864, if you agree, we are passing the order now only.
No, just the point that I was trying to make, man. Whether it's under the previous act or this act, no compensation has been paid. Now, secondly, my lord, there are decisions of this Honorable Court already. That in 2013, where your lordship was a part of the bench, there was a distinction between 371G.
But therein the issue was they had enacted an act.
Yes.
And that was under challenge.
Yes. Which had not received the assent of the
But then I don't know what has happened. They have gone up to the Supreme Court.
I checked, my lord, and I have not seen any appeal being filed. I checked.
But I'm not sure that an appeal was filed in some proceeding.
I'm not very well, madam.
Do you have that judgment with you?
Yes, madam. I do have a judgment.
So he has tied me now.
And then again, there's a principle of implied repeal, my lord.
No, but I'm only concerned with the larger concept because there are two judgments. Is there any other matter pending before the appellate court here, division bench, wherein this issue has been raised?
No, only in this.
So only two single bench orders we have.
Yes, madam.
One by Justice Ete and other by Justice Soikia,
Yes.
which is under appeal here.
Yes, madam.
What
Oh, yes, one more, yes, ma'am.
Here, the court has proceeded that both the acts are applicable. The state act, another state act 1965 as well as the 2013 act. And after
That is the
interpretation of section 11 of the state act, it has said that 2013 act is applicable. So therefore.
That I have not.
I have that in the list of authority.
Yes, madam.
Lordship, here, even in the admission of the petitioner, if your lordship had come to page.
Because we need not go into any other issue, we only got to decide that issue.
Yes. But even in the admission of the petitioner, that is, I would like to show that is at page 79. Page 79, the petitioner, they have admitted that the state we have our own para 17, your lordship.
You have the state act with you?
Yes, ma'am.
Yes.
So under the state act, as it stood, the compensation is computed under the old act,
Yes, ma'am. Under the old 1890, the old.
1864 act, 1994 act.
Yes. Specifically
So
provided.
Justice Borua's judgment is that the computation now would be under the 13 act.
Yes. Legislation by incorporation.
And there is no appeal against the order passed by my Lord Justice Borua?
No. So Lordship, what the stake we are contending is that Justice Barua is not a sound principle of law. That judgment was not based on a sound principle of law. When it is in contradictory to the statute and to the constitutional provision, it can be ignored. Because of which learned
Now,
it
now
Yes.
okay, we have Justice Barua's judgment,
Yes.
we have Justice Saikia's judgment.
No, it is.
No, this is Saikia.
This is Saikia.
Now,
He
Justice
relied on-
Ete's judgment was an appeal taken?
No,
an appeal?
because that was in favor of the state.
No, the respondents have also not.
Yes,
taken-
no, they have not.
They have
They
filed.
have, yes, they have.
Where is-
filed.
Where is that?
It has not been disposed of. It's pending.
Not disposed of.
No, no.
Pending.
It's pending, yes.
Done. Now we can decide. What is that number?
You have the number? Number.
It is submitted at the bar that सबका नाम ले लीजिए हाँ सबका नाम लीजिए
I'll give a full.
Madam, write down the names of all and it is submitted at the bar that with regard to the issue as to whether the Land Acquisition Act 1894 would be applicable and or the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013 that would be applicable in the state of Nagaland. Writ appeal
I'll provide that.
writ appeal number, madam, she will give you the number, is currently pending disposal. The same very issue having arisen in the present proceedings, we are of the view that the present writ appeal be taken up for consideration along with writ appeal number so and so. When? Next
After the
week?
vacations?
Next week?
Next week. I'm
Oh,
not
you are
here.
not here. Petition.
Second week also, December
Second week?
10th is the last.
10th.
We can try on it.
10, 12, 2025. Right? So that if something is done, the people get something. Now we have to judge, we will have both the judgments issues, then it will be easier for us to decide. But that Mizoram case would be,
No, but there's another principle, my lord. The principle of implied repeal, especially in respect of an item, a subject which is in.
because see, but all done and said, I am with you because I have already in that, I have expressed the view.
Will be applicable for 2013 Act.
Where?
1894 Act or 2013 as your justice.
वो काटिए with regard to applicability of 2000 दो act लिखा I have given two act ना you only write with regard to the applicability of the right to fair compensation so and so 2013.
Much obliged. For hearing item number 9.
This is wrapping me.
Please, your lordships. Your lordships, by this writ petition, I challenge the Rule 7B, Roman 4 and 5 of the Nagaland School Education Service Rules 2017, my lord.
The question is, whether it is indeed a person, but it's equivalent. How many judgments we accepted it was not. It's not.
My lord, before I give into the merit of the case.
All the parties are ready. We can take it up for final disposal.
Your lordship, I'd like to make one clarification for the appreciation of your lordships. Now, the main basis for filing this writ petition was on the basis of the 1988 circular issued by the Government of India, which says that certain qualifications are to be treated as equal with the secular qualification. Now, my lord, this clarification was sought by this honorable court, for which the union has already filed their affidavit. And then the union affidavit In their terms, it will be clear, but in my understanding, it appears to be a little ambiguous because,
Just show me the affidavit.
my lord.
Take us through that affidavit.
Yes, your lordship, it was filed on, received on 25 September 2025
Filed by the union.
by the union, your lordship. The respondent number 5.
R5.
R5. Yes. What is there?
This at page 2, 3A. This is the clarification that they have given. May I read, my lord? Paragraph 3A at page 2. May I read, my lords?
Okay, that sets the tone of this proceedings.
Yes, your lordship, and it appears to show that,
You're not a lit. You come to your the rules. First.
yes, your lordship. Page
169.
152.
152.
152 is the rules.
159 is the relevant one.
Yes, your
Let us
lordship.
go from 158.
My lord.
Which are the posts you are aspiring for?
Hindi teachers, my lord.
In where? In the
Graduate Hindi teachers.
graduate.
In fact, the subject
the high
to be
school.
touched is both, yes, your lordship, as well as the Hindi teachers for the primary stage also, your lordship.
Are you interested in the primary stage also?
Your lordship, that
You have
not
a
need
BEd?
one of contention in this writ petition, but
Okay, both
yes, your lordship.
graduate teachers and primary teachers.
Yes, your lordship.
Now, let us come to the rules. It's at page 159.
Yes, your lordship.
Read it.
Roman 4, my lord.
Hmm.
The required educational qualification for recruitment to the post of graduate Hindi teacher. A, graduate, postgraduate, or its equivalent with at least 50% marks or an equivalent grade, relaxable by 5% for scheduled tribe, scheduled caste, differently abled candidates in either graduation or post-graduation with Hindi as an elective subject at the bachelor's degree level from a recognized university. If my lords may kindly allow me to say one thing here. The language or its equivalent, the petitioners were of the impression that or its equivalent will apply to them, but they were not allowed to apply in the earlier advertisement, which is no more under challenge, your lordship. And the second aspect in the Roman 4A to be appreciated by your lordships in my humble submission is that, my lord, the preference is given to elective subject. Elective is optional, my lords, which my lords are fully aware. Then B, my lord, Bachelor of Education, or B.Ed, BA.Ed / BSc Ed from any National Council of Teacher Education recognized institution. In Hindi term, my lord, there is a B.Ed course, Parangat. But here in the service rule, it is given to us, a preference is given to a secular course, and Hindi course is not appreciated at all, your lordship. It is an admitted fact that none of the petitioners possess the Parangat qualification. Even otherwise, it should have been Parangat and not BSc, not B.Ed, your lordship.
We'll come to that.
My
We'll
lord.
come to that.
Then
Let's
C, my lord,
go slow.
your lordship.
So first is clause A.
Yes, my lord.
It says graduate, postgraduate,
Or
or
its
its equivalent. Bracket over with at least 50% marks. Then there is a further stipulation.
Yes, your
In
lordship.
either graduation or post-graduation, you must have Hindi as a main subject or as an elective subject at the bachelor's level.
Yes, your lordship.
Now, how many petitioners are here?
Your lordship, in this, there are 22 petitioners, your lordship.
22 petitioners. Now, are all the petitioners graduates
Yes, your
or
lordship.
postgraduates?
In the equivalent,
No.
circular, yes, your lordship.
Now we'll come to the equivalence. Now, in the normal university system, are you all graduates or postgraduates?
Your lordship, in the Hindi discipline, they are graduates. But
How?
now, by the
We are only going by this act, rule. We'll come to that is your grievance.
yes, your lordship.
But now let us understand your qualification vis-a-vis the qualification at 4A.
Yes, your lordship.
Are you a graduate?
By the definition of university, we cannot be, because if we have to appreciate
You need not be so detailed. Yes or no? Are you a graduate in the normal university system? No.
No, your lordship.
So none of the petitioners are graduates.
Yes, your lordship, according to the UGC norms.
Now, what is the equivalent qualification you have?
That we have, your lordship. It's Ratna in Hindi.
Ratna in Hindi from?
From different institutions. May I take your lordships to paragraph 3 of my the writ petition?
You can read it.
That the petitioner number 1 is currently serving as the president so-and-so and is also representing as one of the representatives of parent district. He started pursuing his class 10 Parichai in Hindi in the year 2012 and class 12 COVID in Hindi in the year 2013 and graduated Ratna in Hindi in the year 2015 from Rashtra Bhasha Prachar Samiti Wardha and has also completed his degree in his master's degree in Hindi, that is Acharya, in the year 2022.
Okay.
From Rashtra Bhasha Prachar Samiti Wardha.
Okay.
He has also completed his 10+2 secular in the secular course in the year 2015.
So that is the condition with regard to all. They have Ratna.
Yes, they have
List.
Ratna. Yes, all of them have Ratna.
Okay, fine. Now come to B.
Your lordship.
Bachelor of Education, B.Ed, BSc Ed from any NCT recognized institution.
Yes, your lordship.
Whether you have
In Hindi, it is Parangat. Unfortunately, none of us have Parangat, your lordship.
no Parangat.
No Parangat.
So even if we hold that your Ratna is equivalent of graduation, as
Your
you,
lordship. Your lordship.
but still you will not come in because you don't have a bachelor's degree,
My lord. Yes.
education. So that's the end of the matter. And do you have this TET qualification?
We were not allowed.
You cannot be, because
Yes, your
for
lordship.
TET, you will, and that is the NCT prescribed norms.
Yes, Your
So
Lordship.
anything more to be considered?
No, my lord, going by the
Okay,
present
we'll see
petition,
the
yes,
primary teachers also.
Your Lordship.
Let us see primary. Do you have a senior secondary or a equivalent grade? You will say you will have Ratna. That would be
We
the
have
equivalent.
both COVID and Ratna,
Okay,
yes, Your
Ratna.
Lordship.
Now, did you have senior secondary with Hindi as one of the elective subjects?
No, Your Lordship, because we are pure Hindi course students, Your Lordship.
Forget it.
Your
So
Lord.
you have Ratna. We'll hold that you have Ratna.
COVID and Ratna, yes. Your Lord.
Probir.
COVID.
COVID.
COVID, my lord. Not
That
the
is
dangerous
master
COVID,
degree.
my lord.
What is that? What is that? COVID
That is the equivalent of class 12.
Okay. Okay. Now, and Ratna. Okay. Now come to B.
Your Lordship.
PST or DLED or Bachelor of Education BEd, that can be only for the upper primary.
Yes, Your Lordship.
BEd or BSc from any national. Do you have a DLED degree?
No, Your Lordship.
Do you have a PST? PST.
No, Your Lordship, in Hindi term, there is a DLED Hindi also, and another term is there, Hindi Praveen.
That is not from a recognized
No,
NCT,
Praveen, Your Lordship. It is
NCT recognized.
NCT recognized, Your Lordship.
Who?
It's a course called Praveen. Praveen also, yes, none of the petitioners have, Your Lordship.
So none, we did not go into that.
My lord. And the third?
So you say Praveen, Pravin or BIN?
Praveen, my lord.
Praveen.
Praveen.
Is equivalent
or DLED Hindi.
For DLED.
DLED Hindi, my lord, more specifically.
But none of the petitioners have it. So even if we come and hold that A is satisfied, you don't satisfy B and C.
Yes, Your Lordship.
So my lord, how can you challenge this rules?
Your Lordship.
Because this B and C is not the discretion of the state government. It is it's a rule set down by the NCT. I found the NCT qualification somewhere here. Where do I get that? I just found it here. Senior secondary, some affidavit it has come on record.
Your Lordship. No, my lord.
So, Mr. Counsel, how do we examine your challenge when you don't have the ingredients, basic ingredients? It's not a question of equivalence now.
Your Lordships may kindly appreciate this point. I had even envisaged to withdraw this writ petition before arguing before your Lordships. But my lord, here, one aspect which I wanted this Honorable Court to consider was that earlier, all those who have these qualifications that the present petitioners have were appointed over time as teachers.
I'll come to that. I'll come to that. Where is that NCT thing? It is a settled law. There are several Supreme Court judgments on that it is the NCT who would determine the norms, and that is a binding. You can go above that. The state can go above that. Say if the NCT says higher secondary, state can say we want graduates. No, but NCT says graduates, state cannot say class 12. That's the settled position of law.
Yes, your Lordship.
Now, if that be so, without a challenge to that NCT, yes, page 10 of the affidavit filed by private respondents. So you are appearing for the private respondents? You are appearing?
No, your Lordship, the challenge to the advertisement has already been taken up.
Taken up. That is only the rules.
They are no more in the
No,
case.
they are not. But the affidavit, fortunately, is there for us. Now, this is the notification of NCT for 2014. And this is under the provisions of the NCT Act 1993. Now, please come to page 11. 1 to 8. And senior would be graduate, postgraduate from recognized universities with at least and Bachelor of Education from so-and-so recognized university or so-and-so or 4-year degree. Now, this being there, and it only not being an educational qualification, a university degree or a postgraduate degree, also a B.Ed degree, mandate of the NCT, we cannot help it. So, if you want to withdraw it, I'll permit you to withdraw it. Come back if you have anybody wants, because if we decide this, your entire Hindi aspirants would go.
Yes, Your Lordship. So, Your Lordship, before the withdrawal, I actually wanted to place one submission before Your Lordships. I feel sorry for the petitioners also. I feel for them because
can't help it.
It's a matter of right to life is also applicable for the fact that their qualifications
go
down
away
the
with
drain.
the feeling that when we dismiss a matter, we take some pleasure. It's pain. And coming from Madam is also, we also have come from that side only. We don't understand that pain. But when the law is set, we cannot be, what do you call that, knights in armor here.
That I fully agree with Your Lordships. Then I may be allowed to withdraw with liberty to file afresh in the future if the need for so arise.
The Mr. So-and-so learned counsel for the petitioner. The petitioners, after attempting to argue the matter at some length, submits on instructions that he be permitted to just cut that. Just cut that. I'll not put him into trouble. Cut that. Hurt Mr. So-and-so. Sabka naam le lijiyega. So one naam le lijiyega. Somebody just write down the names for of all the
My name
parts.
is Joshua. Just
Just write it down. Madam,
Joshua.
Madam, she's the young girl. Just write down names of
All the councils.
with the respondent numbers. So and so. Miss, she's the additional. Miss Additional Advocate General at the outset has raised an issue with regard to maintainability of the challenge by the petitioners herein to the provisions of the rules of the rules. She submits that none of the petitioners have the B.Ed qualification and or its alternatives as spelled out in the said rules. She submits that even if the petitioners are successful by establishing that they have an alternative qualification to the prescribed qualification of graduate or postgraduate degree from a recognized university, still the petitioners would not be entitled to challenge the rules as they do not have a TET qualification and or a B.Ed qualification and or a TET qualification. Mr. So-and-so learned counsel for the petitioner, after attempting to argue the matter at some length, noticing the preliminary objection raised by the learned additional advocate general in the matter, submits on instructions that he be permitted to withdraw the present writ petition. The prayer is not objected to by the learned counsel for the respondents. In view of the above, the present writ petition stands dismissed. However, liberty is reserved to the petitioners to institute fresh proceedings in the event any fresh cause of action arises in the matter.
Bless your lordships.
Because this issue was already decided in the principal bench, me and chief, same very B.Ed that degree thing. Not Ratna. It was with regard to the normal stream.
For hearing, item number 10.
May I have your lordship?
Hmm.
Your lordship, I'm appearing on behalf of my.
Have you got that number? Chief Justice and just give me those 3 files, the other 3 files. Uh, 17, 18. Item number 17 and 18. And also item number 22. On this. This one. No. This one. 27, 8 order. Give Madam 22 file. Item number 22. Got it.
This one.
This one, huh? Same issue.
Stephen. This one.
So we'll have to now hear all these things together. Item number 22 today, the issue was flagged by this division bench. Right?
Yes.
So we'll have these matters together next week.
Okay, lordship.
Same issue here.
Same issue.
Regarding with item number 10.
Now we are concerned with item number 10.
Oh.
10, 17, 18.
No, lordship, 17 and 18, they are challenging the office memorandum.
Okay. And then 22.
19 to 22.
19 to 22.
Yes.
Right. Huh? Right then?
They are challenging the OM dated 2004.
2004 and 2015.
Same.
In 17 and 18. Whereas in the other cases, the petitioner are claiming the benefit under
Benefit
that.
under this. Yes. There is a group which is challenging these
Oh,
ones.
this orders. That we'll keep it separately. When?
Next week, your lordship.
Item number 10. It is stated at the bar that the present writ appeal is to be considered along with writ appeal number 5/2025. Also, the Learned Council for the parties pray that the matter be adjourned today and taken up on when? 3/12/2025. Also, prayer accepted, registry to list this matters, this writ appeal along with writ appeal number 5/2025 on 3/12/2025. 5 what likhi bhi? Huh? List this matter along with WPC number 4/2024 on 3/12/2025. Huh? Will do no?
Lordship, along with WA number 2 and 3 also.
2 and 3.
2 and 3 also.
That is listed today,
Yes. Item number 19.
90,
Yes.
2 and 3.
Yes.
4,
2, 3, 4, and 5. To
So,
be listed along with 2.
along with 2, 3, 4 and 5. Huh? Right? Are 2, 3, 4 to ekalagi ase? Eta order maribi? Huh? Writ appeal number 2, writ appeal number 3, writ appeal number 4. Right? Registry to list this writ appeal along with writ appeal number, ito item number 10 on. Along with writ appeal number 2/2025, 3/2025, and writ appeal 4/2025 and 5/2025. Right? Next order about 19, 20, 21. Registry to list this matters as prayed for, as agreed to by the Learned Council for the parties. Registry to list this matters again along with writ appeal number 4/2024 and writ appeal number 5/2025. Huh? Tarpisha writ appeal number 5 what likhi bhi? raised it to list this matter along with writ appeal number 4/2024. That will do. It come together.
Your Lordship.
Vote your lordships.
For hearing item number 11.
Yes, yes, yes.
Appointment is to them. Who is for the petitioner? You are.
Yes, your lordship. I'm for the appellant,
No, I want a petitioner.
the petitioner.
No, petitioner is not here, my lord.
Where is he? He has not come.
Your lordship, the ex parte passed because he refused to appear even after dusty service was effected upon him. My lord, here the brief facts of the case is that I was appointed as a medicine carrier under the Department of Veterinary and Animal Husbandry in Nagaland.
Was there a big commotion going on at that time when your appointment, proximate to your time of appointment, that a recruitment process could not be taken up? Was there a commotion, unrest, social strife?
Nothing of that sort, your lordship.
Nothing of the sort. Then
Yes.
why a selection process was not resorted to?
So, your lordship, it
You
is an
were
admitted
advised,
fact
you were
that I was
advised,
appointed. Yes, your
some advisor advised for your appointment and you were appointed. How can that be justified?
That is why, your lordship, that is not under dispute. So my
So
termination,
your termination, you're accepting.
I have accepted, my lord.
Now,
But,
what about the fact that there were two persons already appointed?
so the two persons who were appointed, it is the petitioner who challenged my appointment. My appointment was terminated by this Honorable Court. Now, this Honorable Court, while deciding the issue,
Interfere with his appointment also. We do that without. Where is he working now?
my lord,
The writ petitioner?
the writ petitioner, is working in the same post at Sungro. That's
Under which authority?
under the veterinary officer, Wakha.
Madam can get hold of him.
Through the office.
Office. The matter was taken up for consideration. Upon hearing the learned counsel for the parties, this court is of the view that the appointment of the petitioner as directed by the learned single judge would mandate an interference, as it is brought on record that two members of the family of the petitioner, of the clan of the petitioner,
Yes, your lordship.
clan of the petitioner have already been extended with appointments in lieu of the land that was donated by the clan to the government. If that be the position, the petitioner, the clan cannot be held to have a claim to a government job in perpetuity. The learned single judge, while considering the said issues, refused to interfere with the refused to entertain the same by opining that the post in question had fallen vacant in 2016,
My lord.
whereas the notifications wherein such bar was brought in was issued in the year 2018.
My lord.
This court, we have on examination of the notifications involved, found that the same to be clarificatory in nature, which would have the effect of the provisions brought which would have the effect of the decision brought on record, while the same to have a retrospective effect. It is further seen that the petitioner, that the respondent number 1,
Yes, your lordship.
oblique writ petitioner not appearing in the present proceedings. This court had already passed an order for proceeding in the matter ex parte against the respondent number 1. So, however, Considering the tentative view which has been taken by us today, we are of the view that the presence of the petitioner would be required to be heard in the matter. Accordingly, we request the additional advocate general, Miss so-and-so, learned additional advocate general, to intimate the petitioner herein about the next date of listing by issuing a written communication along with a downloaded copy of this order. You are for the petition?
No, I'm for the state, my lord.
Oh, that's it. Oh, we can ask you.
Yes, my lord.
Ask it. I'm sorry, I did not know. Mr. Swanson, learned government?
Yes, my lord.
Advocate?
Yes, my lord.
Government. Along with a downloaded copy of the present order through whom? Director?
Director, yes, Animal Husbandry and Veterinary Service.
Director, Animal Husbandry and Veterinary Services, Nagaland. Also, on effecting such service or on the petition are being served with the copy of the present order, an acknowledgement thereon be procured, be received from the respondent number 1 obligate petitioner, and the same be placed before this court before this court along with a forwarding envisaging the service of such order, envisaging the service of the same upon the petitioner. Registry to list this matter again on. Give me a date.
My lord, same direction was issued on 13/11/2024, and the service was already
done.
Done, yes, my lord, and the acknowledgement receipt was already submitted, my lord.
Or through the office.
Yes, my lord. Your lordship may kindly see the complaints affidavit.
Anything more?
Now, your lordship, the learned single judge, instead of appreciating the settled principle of law, given the position that the writ petitioner, the present respondent number 1's family, had already benefited with 2 appointments. So the direction should have been advertisement, my lord.
I have highlighted that.
Yes, your lordship.
In my although the deleted order now, we'll reiterate that, and we will while we will reject your prayer for appointment,
Yes,
for
your
protection of your appointment, we'll also interfere with the appointment of the writ petitioner. And then we will ask the government that the post being now necessary, we'll advertise in
Yes, your
accordance with law.
My lord, in the process, I have become overaged, the appellant. So if that.
Okay, we'll give you a liberty to approach the authorities with a prayer for condonation of your overage.
In fact, it is by
In
the.
view of these provisions.
My lord.
If they condone, you appeal.
My lord. Bless you, lord.
Anyway, also you have good connections, so maybe they will do that for you. There are advisors waiting for you.
Your lordship's governments come and go.
Okay. Sign. See? I'm not sure. This is the only portion that it is done. He says, they will rely on so which provides the appointment and perpetuity, and the same is posting question tell vacant one, promotion of so and so. And therefore, 2 notification and contract.
My lords, I may be allowed to point out one document to your lordships. The affidavit filed by the state respondents, 2, 3, and 4, your lordship. Appointment of the petitioner.
That we will interfere.
Yes, your lordship.
That
It's
we will
already on
interfere.
record.
That we propose to interfere.
Your lordships. Your lordships.
Much
This was, dismissed. Give it to me and.
Yes.
For hearing item numbers 17 and 18.
Mr. Council, this matter also long way to have only they are claiming benefit.
This one, they're claiming benefit.
If this goes, everybody gets it. We propose to take it with along with that series that we have created today, wherein they are claiming benefit under that.
Yes, madam.
But
But our lordship, here, the learned single judge has not interfered, has no question set aside.
I know that.
Yes, yes, yes.
I know that. But they are here before us.
So unless he, because the appeal also is not maintainable, because there are so many work charge employees who are claiming a benefit under the OM. So petitioner has to make them as a party respondent, because if at all, if anything goes wrong, then.
No, it will only, madam, they will always get it. He is trying to make it more reasonable, to bring it within his limits, because he does not have that edge, because there are two things required under that 17(3). If I have understood it
Yes,
correctly, one is that you must be working for 30 years along with a pay scale.
Yes, now government, we have given them the pay scale by this year, lordship. There is an office memorandum.
You're still working, you have retired?
No,
He's
we are
still
working.
You have got your scale.
No, my lord. The learned single judge has held that I'm not entitled to scale pay also. There's a difference in this case, man.
No, but after that, your lordship.
I will not accept that, man.
Government has brought out the office memorandum.
This
where-
year.
Yes, so they will be given the scale of pay. So the appeal also become infractions.
Now 17(3) has been modified again.
No, my lord.
Modified.
Another benefit.
But-
What is that?
So in terms of this OM now, you're getting the
They will
scale
be
pay?
getting.
We are not
lordship,
getting yet.
yes.
You're not getting.
They will be getting by first.
Have their names been registered in the PIMS?
If they are a genuine, then they will be in being.
Have you
No.
got it?
Nothing, we are not getting any benefits. Your lordship, in this case, your lordship, I am challenging the memorandum. In the previous cases, the memorandum is not under challenge. There's a difference between this case and the other batch of cases.
You are challenging the memorandum on the ground?
Memorandum is unreasonable.
Why?
There are two memorandums, as your lordship is aware,
2004 and
2015.
15.
Now, 2014 prescribes one criteria, 2004 prescribes one criteria, 2015 prescribed another criteria.
How are these two memorandums operated?
That is why, that is again another point, your lordship. Now, there is already a decision of the division bench of the Honorable Court that 2015 applies and 2004 will apply only in as much as it is not inconsistent with 2015.
Because that's the subsequent decision.
There is a subsequent decision.
So,
But in this case-
implied repeal of 2004 comes in.
Yes.
So
But in
forget
this,
2004.
no, my lord. In this case, what has happened is this. The single judge, after that decision, has
One question,
inquired.
just one clarification. When were you all recruited, engaged in those cases?
Get a moment.
You have the 2004 OM on record,
Pardon me, my lord?
2004 OM on record,
Yes, my lord.
page
2004 appointment, please.
48.
Page 48. Page 48, man.
Now, where is the 2015 is at page 50.
Page 15. Page 15. Now, why I am saying my case.
When were you recruited?
My lord, in my writ petition, which is at page 20, beginning from page 21. 21, 25, 26. The statements are at page 27, paragraph 3. So 2003, madam.
So a formal order in your case came only on 2/6/2014.
Yes, madam. Yes,
So from that day, we'll have to construe your services because
Well-
earlier period we cannot because they have disputed that.
Very well, madam.
So if it is from 2014,
My lord.
so you will be placed somewhere in that list.
If I may, madam. This case was unfortunately clubbed with the other cases. Unfortunately. And I had taken time to file a reply.
That plea you have taken.
Yes, my lord. I had taken time to file a reply.
And some deliberations with the learned single judge also you have brought on.
Yes, my lord.
Forget that now. Now we are considering it. Now, you will be an appointee of 94 or 2014?
2003, my lord. 2003.
No. You will be an appointee of 1994 or 2014
94.
or 2014. 94 when you substituted Neeraj in item number writ appeal 25.
Yes, my lord. Paragraph 3 says 23, man. 2003. In the year 2003. Page 27.
You say 1994.
Page 27. Is your lordship on page 27?
2000.
Repeal 25.
Which is the?
This is the bill 25.
25. Oh, this is 26. Okay, sorry. Cover is 25.
Cover is 25. Cover is 25. I mean, inside this is 26.
26. Just change it. Okay. Since his appointment, petitioner has been continuously 2003. So after you joined, 2004 came.
Yes, madam.
Okay.
Yes, madam.
And it says 50% of regular vacancies of similar nature arising in a year will be reserved for regularization. Fine. And then it is your own case that 17/3/2015 is a revision of the earlier scheme.
Yes, ma'am.
So after, if it is a revision, after revision, the revised part will remain,
Yes, madam.
right? There are categorical statements to that in there. Now, if it is not the 2004 scheme that will be in operation, it will be the
2015.
15 scheme.
Madam.
Now, 2015 scheme envisages two things, 30,
And scale pay.
forget the scale of pay. 30 you have not come.
No.
Now, can you challenge this prescription with regard to 30? That is their discretion. We should not come in.
That is why I am saying, my lord, that prescription of 30 years is unreasonable.
That's their, they'll
Yes, my
have
lord.
to, because see, they are contemplating to give the benefit to all. And Supreme Court has also said that the terms of a scheme
My lord.
should not be gone into by this court.
But that does not mean, my lord, that it is an absolute bar.
So how can we,
But is that
we-
an absolute bar?
we uneducated in administration matters say, or uninitiated in administrative matters say, no, there should be 5 years, 10 years.
This honorable court has already held that 30 years is not an absolute bar. There are many decisions, my lord. in this bench.
That cannot be a decision other than a decision of a division bench.
Yes, my lord.
We are in a division bench
Yes,
today. We can consider that.
Yes, my lord. And no, the point is this, my lord. Is it an absolute bar? Review of such a scheme, my lord.
It would be.
My humble submission
But
is that it
now
cannot be. a
you are
simple-
already in service.
My lord.
Without inviting us to finally have it closed here, why don't you accept the pay scale that they are now advancing to you in terms of the fresh policy?
The skill pay part is all right, my lord. Skill pay, but the fact of the matter is.
Okay, now you show us how this 30 is unreasonable.
The two decisions, the two latest decisions of the Supreme Court, my lord.
Yes, that decision is again in a situation in a vacuum when there was nothing. And it says that the man is working for the last 3 decades. Jaggo Dharampal.
Why not?
3 decades.
Why not?
So there again, it's 25 to 30 years.
Therefore, is 30 years is not an absolute bar, my lord.
No, if the government has decided that, will not come in. We should not come in. We should not come in.
The Jago, if my lord will kindly appreciate this, the Jago in the other case has been passed notwithstanding rules, not just schemes. Not just schemes, my lord. And if the Honorable Supreme Court can ignore the rules in a manner of speaking, my lord,
It
and to
has
say,
141 with it. We don't have that.
still, my lord, service rules, still,
This is the rule now for you.
it's a scheme framed under a regulation.
That's it. In absence of a rule, it will be the scheme which will be up.
And if the scheme is absolutely arbitrary, my lord,
We don't think this to be arbitrary. We rather feel that the government was conscious to the needs. At the same time, maintaining its administrative and financial constraints.
Jago
You show
says-
me a decision of the Supreme Court that this court has the power to interfere in a scheme of regularization. Immediately I'm doing it.
Jago and the
There
Dharampal
is,
case says that
that is only a,
it doesn't talk about a scheme.
it only says that Jago there was working for 25, 30 years. So you have taken the services of these people for such a long time, regularize them.
Agreed, my lord.
But here, the state is not denying that. It is saying we will do it. But
No, my lord will
this-
appreciate. There's another point which my lord will appreciate. The Honorable Supreme Court has said, if employees are to be regularized, it can be done under a scheme. Jago is not under a scheme. Dharampal is not under a scheme.
Difficult.
There are other judgments, your lordship.
Who's man? Sorry, it's done. They have taken care of. You also have to consider the financial aspect and the other developmental activities of the state.
The other judgments also, your lordship. 20 years has also been taken into account by the Honorable Supreme Court.
Those are on a case-to-case basis. But now that uniformity has been brought here,
Yes,
30 years, it's wisdom of the state. Why should we go into?
The Honorable Supreme Court says 20 years is also sufficient time.
It is all interconnected.
Madam, we'll have it with the other.
I'm
batch.
not here on the third, my lord.
Okay, we'll have this after the vacations. Not.
No, but your lordship, the principal challenge, of course, what your lordship is saying is connected, but the principal challenge is with the decision of the learned single judge.
No, that decision we can take care of with regard to the pay scale. That we can take care of. And now we did not do much work. The state government has come up with the thing. So no interpretive thing is required to be done from us. We'll only have to follow that. If you want that, we'll do that. But the challenge to this is somehow not being palatable. And I have been open with this. I have passed judgments considering Jago, considering Dharam. It's pending in the Supreme Court. Let's see what happens.
Then let it be after the vacation. Yesterday when we were discussing the issue, the same case is coming up sometime in December. We were told.
Same issue is coming up. So this will have a long-term consequence. As agreed to by the Learned Council for the parties, registry to list this matter again. You will be back by
I'm back on the 6th.
6th of December.
Yes.
So we'll have it on 10th, 10,
No,
10, 12.
after the vacation.
Let's have it. Let's try once.
Because many matters are fixed.
Chief,
8,
I have problem. I have other engagement. Yes.
then after the vacation.
After vacation.
After the ensuing winter vacations on a date to be fixed by the registry. But there are contradictory decisions of this court in the matter. There is a body of judgment which says, okay, 20, 25 also give it. Yes. There are there is another body which has gone up to the Supreme Court, although it was by the wife who had gone up, but again, the principle would apply, which says that no, the court is correct in not passing the order for grant of pension because the man had retired and by the time he had not completed the mandated service.
And not only that, the state themselves, they have said that 30 years, it is not necessary that people.
I have found in one case a submission of the government council.
Yes, yes. Why
Ah.
a person need not wait for 30 years? Is that if he's in the senior most,
Seniority.
if he is the senior most,
Ma'am,
If he
it
is
cannot,
single,
it
he
cannot be, it cannot be.
no, Lordship, we have to.
See, then I'll tell you one thing. If that be the position, that a person is in VOCA, I know a few places, VOCA, electricity subdivision, a division, he is number 1. But he has completed only 19 years. Just to test your proposition.
Exactly.
There is another person in Kohima who has completed 25 years,
Lordship.
but he is at serial number 20. Now you give it to the person in VOCA, what would happen to the man in
We
Kohima?
Lordship, we maintain as per the category wise, Say, suppose if he is if he is
One state, one
yes,
state.
yes, if he is a plumber, if he is a jugali labor, so they will have a different list, Lordship.
Can you make that statement? Can I record your statement? I think you are agreeing to what the council is saying.
Then Lordship,
That 30 years is not a
Hard and fast.
rule. It can be modified.
because there is an OEM 2004. The 2000 OEM says that a regularization will be based on seniority, the 2004 OEM. And the 2015 OEM says that if he is enjoying scale of pay, then if he served for 30 years, then he will be automatically, his post will be converted.
I was given two division bench judgments wherein the person retired. After retirement, he had completed 35 years of service, but he did not have a scale of pay. Both these judgments allowed, saying that give him retrospectively, but only for pension. It was placed before me, my hands were tied, I had to follow that.
Lordship, some decisions were also passed accordingly, which we have filed an appeal, Lordship.
Anyway, if I come down for 2 weeks, we'll consider all these things. Okay.
Much obliged.
For hearing, item number 24. May I please, my lord? This is an appeal. This particular appeal has been preferred by the Chief Institute of Horticulture. And Chief Institute of Horticulture is a department under the Ministry of Agriculture and Family Welfare, my lord. By way of this particular appeal, we are challenging a judgment and order dated 27/11/2024, which is being passed by the learned single judge. In that particular judgment, my lord, the learned single judge has directed that both the petitioner, relevant to item number 24 and 25, both the petitioner should be directly recruited to their existing post. And there is another aspect, my lord. The revised recruitment rules came into existence in 2022. Following that recruitment rules, my lord, an advertisement was floated in local and national newspaper in 2023.
Delay has not been condoned.
Delay has not been condoned, my lord. So before coming to the
Yes, what is the objection with regard to delay, Mr. Counsel?
Lordship, may I take a lordship to IA 121? That is.
I'm holding
Now-
that.
Your lordship, the grounds which they have given, the applicant has given for the delay, the explanation, is starts from para 3 to para 8, your lordship. Now, in para 3 to para 8, your lordship, in every paragraph, what has been mentioned is only the dates, your lordship. Only the date.
Okay, they
So-
have at least given some explanation with regard to the delay.
Delay
Which
by
is
but-
administrative decision-making
Yes.
process.
So in that condition, May I place
Chief-
for your
Chief-
lordship, just one case law, your lordship.
Chief Postmaster.
Yes, Chief Postmaster.
That we will not apply.
Now,
here.
your lordship.
We'll not apply here because we would like to examine this case on merits.
No, if your lordship wants to examine it on merit, that is different. Otherwise, the explanation given, your lordship, in my
We'll take care.
that is not sufficient.
Okay, what is your case with regard to merits?
Oh, my lord, then allow me to come to the read appeal, my lord.
No, we'll ask, we want a clarification from the learned counsel for the petitioner. What was the initial recruitment?
Initial recruitment, your lordship, they were recruited through an advertisement, both in local.
This post of horticulture specialist was advertised?
No, as consultant technical.
Tech.
Yes, your lordship.
Now, this post is placed at what level in the organization?
Assistant horticulture specialist, your lordship.
And assistant horticulture specialist is a group A, B, C, what post? Group B.
That, your lordship, I think it's.
How is the recruitments to assistant horticulturist made?
Either by way of deputation, which includes contract, short-term contract.
Short-term.
Short-term contract. So by way of.
This post is not required to be filled up by UPSC.
No, as per the service rule, your lordship.
Where is that
And-
service rule? Can you take us to the advertisement at first, initial advertisement?
Actually, your lordship, I have not been served copy of the appeal memo. I have only the IE with me, your lordship.
We condone the delay and we will hear the matter.
If your lordship wants to go into the merit, that is different. Otherwise, your lordship.
We feel that this matter on merits we require to be.
Well, that I leave it to you. Otherwise.
You are still in job? You're working?
Yes, I am working. They are working.
Let him work till the next day.
Your pleasure, my lord. We have no objection to that.
Heard learned counsel for the petitioner. Mr.
See that, my lord.
Better dictating them.
So I've also heard learned counsel for the respondent, Mr. TB Jamil. Only one respondent, no?
No, there are 4 respondents, I think.
Oh.
Let me go through it, my lord.
State also, sir. I will.
Okay, who's appearing for 1, 2, 3, 4?
Yes, my lord. 1, 2, 3, 4. Yes. For all there is only solo respondent, my lord, in this.
Only sole respondent.
Sole respondent is
Only
there.
applicant, only
Yes, yes. no, no.
Writ petition now.
Yes.
Only
For the sole respondent, TB Jamil for the sole respondent. Stop. Well, the present application under Section 5 of the Limitation Act 1963 has been filed praying for condonation of delay of 199 days in preferring the connected writ appeal 12 of 2025. Stop. Well, the cause for the delay has been set out at paragraphs 2, no,
3 to.
paragraphs 2 to
I think it's from 3 to 8.
3 to 8 of the application. Stop.
3 to 8 further.
3 to 8.
3 to
3 to 9.
no, if you go for the 11,
Oh,
12, 13, 14,
3 to 14.
14.
3 to 14 of the application. Stop. The main causes for the delay, which has been shown, is that instead of administrative communications and the administrative process involved, as the legal opinion had to be sought and various communications had to be exchanged between the Council and the Ministry of Agriculture and Farmers Welfare. Ministry of Agriculture and Farmers Welfare. Stop. As well as the Department of Personnel and Training under bracket DOP&T, close bracket, as it is the nodal agency in respect of service matters. Moreover, the matter also had to be referred to the Ministry of Agriculture and Farmers' Welfare to take the comments of the DOP&T to ensure the feasibility of filing the instant appeal. Stop. Para. It is also stated that eventually the Deputy Solicitor General of India was contacted by letter dated 23/6/2025 who had communicated the appointment of the advocate Shri B. Deka as the learned engaged counsel in the instant matter. Thereafter, on appointment of the learned engaged counsel, the applicant number 4, white letter dated 24/6/2025, shared the details of the instant matter with the said learned counsel. Stop. The learned engaged counsel took some time to prepare the draft of the appeal, and thereafter it was sent for vetting and signature. And it was returned to the learned engaged counsel for filing the appeal before the Gauhati High Court, Kohima bench. Stop. Para. The appeal was eventually filed. When was it eventually filed? Okay. Eventually filed immediately after reopening of the winter vacation. No. After reopening of the vacation, which was from 29/6 to 13/7/2025. Stop. Para. Thereby, the application hearing was finally filed on 15/6, isn't it? 15/6 or 15/7/2025, with a delay of 199 days in filing the same. Stop. Para. Upon going through the reasons as shown by the applicant herein, we are of the view that sufficient cause has been shown by the applicant herein, and accordingly the delay of 199 days in filing the instant appeal is condoned. So application stands allowed. Then in the main case, in the main writ appeal, okay, in view of the order passed in IA Civil 121 of 2025, the instant appeal is admitted. The petitioner, the respondents are already represented. The respondent is already represented by counsel, and therefore no formal notice is called for. Stop. The copy, no? The counsel for the appellant shall serve a copy of the writ appeal on the opposite counsel. How much time will it take to serve today?
Yes, madam.
During the
We will
course of
serve
the
the copy today.
Okay, during the course of the day. Stop.
Since it's our station, I'm just saying for.
For a date, yes. Yes.
When will it become, Mr. Bova? After the vacations. Right, ma'am?
Okay. List the matter, that can you please state? When?
If this fixed in January, I do not have any problem with
28?
28.
28 list on 28 January 2026.
For hearing.
For hearing.
Kindly give the copy.
Yeah, today, my lord, I will serve them the copy. Like, similar order in other.
Similar order.
It's next to the same, what is it?
Same.
Same order.
Same.
only the IA will be different.
I number will be different, writ petition, writ appeal number will be different. 199
Yes,
days.
Your Lordship.
Thank you. We have to
So,
go for the.
oh, yes.
Imagine